Welcome once again to another episode of Scott Talks Law. So in this episode, we're going to talk about the sources of refugee law. So we've got 6 sources of refugee law. We've got the 1951 Convention for Refugees. We've got the International Human Rights Law. We've got the International Humanitarian Law. We've got the regional conventions like the 1969 OE conventions governing the status of refugees in Africa. We've got customary international law, and we've got also the national and municipal laws. So the 1951 conventions for refugee is the main legal source of refugee law, and this provides for the definition of a refugee. And the definition according to that convention is that a refugee is someone who has been forced to flee from the country of origin or his national country because of well-founded fear of persecution on the basis of nationality, color, origin, opinion, or belonging to a particular social group, and he is not able to return on the because of that well-founded fear. So this convention also provides for the non-refoulement principle, and it also provides for the rights and prevents the refugee from discrimination and defines the refugee status as declaratory. So it also the refugee must be accepted without further variations by the statute, and it provides for the rights and freedom. Freedom from discrimination, freedom of religion, freedom to access to courts, rights to be protected from refoulement, and it creates an exclusive catalog of rights. And if there's another law that provides for similar rights, the refugee is entitled to a higher standard of rights and to benefits of higher standards. It creates rights that are defined by a mixture of absolute and contingent rights, and it depends on the outcome to get the rights. So the second law is the International Human Rights Law, and here we have the ICCPR, the International Convention on ICCPR, and the UDHR, Universal Declaration of Human Rights. So the UDHR, any person is not supposed to be discriminated on any grounds of race, color, nationality, origin, opinion. And the ICCPR, the International Convention on Civil and Political Rights, it's also an international human rights provision, or under the source of international human rights law. So you've got the International Humanitarian Law, and here we've got the Geneva Convention. So the Geneva Convention is also another source, and you've got also the regional instruments like the 1969 OA Convention and the provisions there, and you also have customary international law. And customary international law, these are rules that are widely accepted or practiced that are opinion juries that are not supposed to be derogated, widely accepted by many states. So state practice that is mostly widely accepted, jus cogent, relates to certain rights against which there can be no derogation or limitation: right to life, right to dignity, right to freedom from torture. So they have got 3 criteria or tests. Provision is a fundamentally norm-creating character. But 3 tests that are there under the customary international law, and the provision is a fundamentally norm-creating character. Participation of states is widely spread and representative. So this practice must be widely spread so that it can be accepted, and the state practice must be both extensive and virtually uniform. So we've got also the national laws, the constitution, the provisions of the constitution, the penal code, the Refugees Act, the Kenya's Refugees Act, the legal system, the dualism and the monolism. So the OAE Convention 1961 governs the aspects of refugee problems in Africa, and refugees applies to any person owing to external aggression, occupation, foreign domination, and events seriously disturbing public order, either part of the whole country of origin or nationality, and is compelled to leave the place of habitual residence to another country to seek refugee. So there's that definition as per the 1969 OE Convention, and according to this provision, a refugee is someone who is owing to external aggression, occupation, foreign domination, events seriously disturbing public order, either part of the country of origin, nationally compelled to leave the country. So external aggression that may be of external nature. Occupation, maybe other countries have occupied, other states has occupied the state, so this person is forced to leave. Foreign domination, they have been dominated. Events seriously disturbing public order like earthquakes, floods, any event that might disturb public order, either part of the whole country, must not necessarily mean the whole part of the country, but just any part of the country. So is compelled to leave the place of habitual residence and is not able to return. So when either part of the whole country is disturbed or faces that this events disturbing public order, if they occur either part of the whole country, even if they happen on just one region of a country, can move to a different country and can still qualify as a refugee as per the 1969 convention. So or you can choose also to locally disintegrate or locally integrate. There's that one, the durable solution of refugees, local integration. But if you feel like you just need to move from your country, you can still move as per the 1969 convention and qualify as a refugee. So those are the sources of refugee law. The 1951 United Nations Convention, Refugee Convention, the International Human Rights Law, International Humanitarian Law, the Customary International Law, the Regional Conventions, the OAE Convention 1969, and the National and Municipal Law. So that's the end. And come on, you guys, we're gonna do this.